So, yeah, I'm Seema, and I'll be dealing, are really reeling from economic downturn. And what we as law firms, because I'm the sole law firm representative on the panel here, we are seeing there is a lot of constraint, a lot of negotiations which is happening from the corporates at this stage. Now, this economic situation is further compounded by the fact that there are a lot of competing law firms providing a new law firms, being set up across the board, who are providing excellent legal services, but at very, very, competitive rates. The third dimension to the entire landscape is that there is a lot of in-house counsel teams, which are, as what you said, mini law firms being within the corporates being formed. Within this landscape, we have a situation where a lot of our work is flowing out of law firms with the in-house counsels, a lot of competitive law firms, and the economic downturn. And we are faced as law firm owners and practitioners where alternate billings are being looked at. A lot of alternate billings, I'll go into in detail, but let me ask you the first question, Arunji. What do you feel? Do you feel as a corporate a constraint right now to engage with external counsels or have large legal budgets?
So, thank you for this question, Seema. Very interesting debate. So, as I said in my earlier session, the in-house legal team in most of the corporates are changed a lot today, what it was 10 years back. So, today, the lawyers who are in-house lawyers are equally competent. Many of the work which was earlier given to an external law firms are being done in within the corporates in-house, and therefore the opportunity for a work in the law firm, unless it is diversified, has changed. These opportunities which existed 10 years back is different from what it exists today. So in terms of continuation and business continuity for the law firms, you will have to come up with new ideas, new ways of pitching in with the client. As far as we are concerned, as your clients, yes, there is definitely a budgetary constraints, more and more pressure from the organization on doing the work in-house, less outsourcing of the work to external lawyers and external law firms, because like any other business, we are also under the budgets and the overall financial planning of the year.
That's pretty bad news for external firms. Sanjay, what is your view? Is a higher legal fee proposal, is it a deal breaker for a corporate? And are there any exceptions to when you are willing to spend the extra rather than the standard rates?
Yeah, I think higher billing rate as a standard asking may not be accepted. The question is that when there is a real need and there is a real validation coming from the law firm in terms of that particular subject, maybe when we talk about a due diligence being done for merger and acquisitions, or when there is compliance and ethical aspects have to be looked into from a business perspective, and there is a framework which need to be implemented as a process, then I think the organizations are willing to seek the external help, because there's a lot of intellectual and there's a lot of experience the law firms carry, and it's very valuable for them to get this structured advice and implementation across the organization, and even bringing a protection for the organization from any future risk. So I think the entire risk management perspective, when an organization see, they are willing to pay a higher fee or a reasonable fee which matches the efforts of a law firm.
Okay. I mean, I'd like to share some of my own experiences with my own journey in last 25 years. I've seen a paradigm shift from from a billing perspective, not only from the practice perspective, from when I started with pure billing, hourly billing rates. There is a lot of shift from alternative billing scheme which is being right now in place. And these schemes could be from ranging from blended hourly rates to assignment-based fixed fee to cap maximum to minimum kind of a capping, estimation of fees, There could be a combination of lump sum fee plus hourly fee or pure lump sum fee for legal opinions. This is not the paradigm where I started, where everything was hourly, take it or leave it. What are the trends that you have seen, Arunji, in the last 5 years, I would say?
Yeah, so definitely the trend, Seema, has changed considerably. And let's divide the segment into two components. One is the litigation lawyers and the non-litigation side. I'll give you my own experience and more my own examples. So when I'm dealing with a litigation lawyer, barring the senior designated consuls of this country, I have devised a complete rate list which is based on a stage rather than leaving it open-ended on an hourly basis. So as a lawyer, I know what are the stages involved in a particular litigation, be it an arbitration, be it a court litigation, be it a writ petition. So I understand. So I have structured it in a manner that every stage has a fee, and we understand what could be a tentative cost of pursuing a litigation. So when I talk to my management, I can tell them that in order to pursue this litigation, these are the tentative expense, right? And then I control that expense. When it comes to non-litigation side, corporate side, there is a push from the corporate. I push it as a corporate client where I don't easily accept the hourly rates. I push for a capping of the rates, and where I cannot cap the rates, I take a tentative expense from the law firm saying that for this matter, what is your tentative estimate? And when that estimate comes, and if it increases, I take a decision whether to go ahead or not to go ahead. And then there are milestone payments as well, right? So this whole concept is changing. The good part is that many of the law firms are accepting this change. That's the best part. It's not that they are resisting it. They resisted, but they understood that even the GCs are under a constraint. They have limited budgets. Organization will not go on spending money on the legal cost unless they see some value into it. So alternative payment mechanism is being accepted and is changing.
Okay. So would it be fair, Sanjay, to say that this is possibly the beginning of the death of the hourly rates? Is it a very pretty harsh statement? What is your view on that as a corporate?
I think there is no fixed way to look at a particular structure, fee structure. I mean, in some short assignments, it's fine to have an hourly rate, and you can really see, yes, there is an effort, but you cannot really estimate the overall time within which it can be completed, or it is wise to say that, okay, it's better that you are being paid for the time efforts, and you are not excessively capping up or agreeing to a fixed fee where it will be quite higher on your assessment. So it is better that, okay, you have spent 10 hours and you can estimate the work that it can take this much of hour. And to that extent, I think both models coexist. I will not say that one can prevail and the other cannot. It's all based on the type of work and the effort involved. One needs to, get into a fee arrangement.
It's a sort of a combination of the two.
Yeah, it's a combination.
But as a law firm, we have a very serious concern, which is related to corporates not paying on time. Can anybody? I am assuming there's a lot of people from law firms. Can anybody raise their hands? Whoever has faced non-payment issues from corporate clients as well? Okay, so there are. I mean, that includes mine. So we have a serious concern here where non-payment. I mean, I can understand startups or financially troubled companies wanting a longer credit line. But some of the names who do not pay are almost like, these are big names who do not want to pay, or they want to pay after 7, 8, 10 months.
7, 8 years or 10 months?
10 months.
Okay.
Years, and then that's a write-off. And in top of that, there are situations, I've heard law firms having situations where the matter has been dealt, they have been finished, the corporate is coming and renegotiating the fee which has been pre-agreed, or even worse, where they have actually won the matters, litigation matters, and the clients have refused to pay. I mean, that's the worst of the situation, where you've done what you're supposed to be doing and you don't get paid. And we as law firms are now compelled to charge 50% advance fee on estimation of a fee, because we are cognizant of the fact that the remaining 50% may not even come. That's a situation we are right now, where a lot of fee goes unpaid. And we're also looking at situations where we are blacklisting. I mean, that's the worst thing to do, blacklisting clients who have not paid, or taking some new work so that the previous bill gets paid. That sucks, to be very honest. I mean, we are compelled to take new work when we know it's not going to be paid, because we need the earlier bill to be paid, and that's a precondition for taking new work. I mean, that's where we are in terms of, our concerns as external counsels. What do you think, Ranji, what is the reason behind, people the corporates not paying even the negotiated fees?
Yeah, so the first is, that's a bad news.
That's a bad
That's bad. I mean, if the corporates have taken the professional services, they should honor the contract and they should make the payments. Now, a couple of things. Definitely, as a law firm, you should have a very good contract, negotiated contract, where these things are very, very clear. So at least your legal rights are protected. You should have a time span within which the payment should come. Understand the reason why payment is not coming. It's just the habit of the organization. There is some structural change, management change, GC has changed, the finance guy has changed, or is your billing is not clear. There may be instances where what you are charging may not be clear, or it may not appear to be very clear or in line with your contracts. So maybe organize a meeting once in a quarter with the GC and the finance guy to talk about the pendency of the bill. Now, despite all your efforts, if they are not paying, I know MSME Act, very stringent, 45 days, right? I don't know if law firms want to register, register under that or not, but that's a very strong act in terms of payment and the interest rate. Second is the Insolvency Act, which gives you a...
We tried that too,
so,
unfortunately.
Yeah.
So, Sanjay, in your view, is it the differing expectations or difference in mapping of what was needed and what was delivered? What is the core crux of this pain?
I think one of the point I can mention, that maybe in some instances when initially the fee is quoted, it's really quoted on a higher side, right? And maybe at that point in time, the client also had no visibility whether it will really end up having this much of effort and the fee is justifiable. So on your first point, it happens that when the work is completed, you are again brought to a negotiation table and it's renegotiated. Fees is renegotiated. So maybe a couple of instances so happen that this time cost effort analysis is done by the organization also, and on a mutual acceptable basis they come back to you and say that can we have a renegotiation. However, on the fee not being paid despite doing the work, I think is unethical, and at least in my experience holding that portfolio, it has never happened that any of the co-professional, I would call them co-professional because we are, and has ever been not paid. So we need to respect, in the industry needs to respect the contribution of the lawyers and the professionals who contribute in their business process, and they enable things for the betterment of the business. It is important that should be respected. I would use this word. And the last point is that the fee in such cases, typically the quantum of fee is sometimes compromised, because you are saying that at least you're getting something. So I think, but that's not a right example. Yeah.
But Seema, just to add, let me give you a very, very positive statement. The intent is good. And I'm somebody who has worked in corporate for last 23 years, and I can tell you the intent of any corporate who has engaged a lawyer under a contract and taken service is never to not to pay. The intent is there. So therefore, there must be some reason or the other why the payment is not getting released.
Well, that's the typical answer which a client would say. There must be some reason, but trust me, there are. If you read the IBLJ's recent reviews, there are 75 law firms being interviewed on non-payment, and all of them have had serious and severe issues with non-payment. So it's not that all the law firms are doing bad work. It's sometimes bad faith, it's sometimes financial constraints, and sometimes, well, maybe the lawyers haven't billed it on time, where I would suggest, quick intermittent billing. Since we're out of time, I'll ask one last question. In single question for both of you, what do you think in a few words would be the best solution for getting the payment out for, as a corporate, that you would expect law firms to do for quick payment?
See, I worked prior to this organization for 7 years. I was the general counsel for Ernst & Young, and we were the world's largest consultancy organization. Now, milestone payment is something which we encouraged our partners to bill it to their clients. Advance payment could be one solution, but again, it's a matter of demand and supply in the market. But these multiple combinations that you need to do depending upon the relationship with your client, and there is no uniform formula for this. Depends on the client relationship, and also that you don't want to lose your client,
So I would say that if there is a right scoping done and a right milestone which is achievable milestone being demonstrated, and then payment is structured on a milestone basis, I think is a very right thing, as Amar has also suggested. Yeah.
Thank you very much for your patience, and thank you very much for the panel. That would be all from our side. Thank you.